Welcome to the Hudson Institute. My name is Harold Scott-Roth, and my colleague Adam Mossoff and I will be your host today for this special session on copyright law and COVID-19. Our speaker today is Stephen Tepp, professorial lecturer in law at the George Washington University School of Law. He's also the president of Sentinel Worldwide. He's previously held high-ranking positions at the Chamber of Commerce and the U.S. Copyright Office. To introduce today's topic, my colleague Adam Mossoff will tell us today about COVID-19 and copyright law.
Thank you, Harold. And it's a real pleasure to be speaking with Steve, who recently published an issue paper with the Hudson Institute on this very important topic titled "A Legal Analysis of Making Copyrighted Works Available Online During the Coronavirus Crisis." Viewers should feel free to visit Hudson Institute's website to download a PDF or read online Steve's excellent issue paper analyzing this very important topic of what happens when a website known as the Internet Archive creates what it calls a national emergency library, which effectively makes available with unlimited access all of its digital copyrighted works on its website. Now, the Internet Archive has justified its position in creating and making available this digital archive of copyrighted works and books and other things, that we are in a national emergency, that people are restricted to their homes, given shutdown orders, and therefore being unable to visit regular libraries, they should be able to download for free, unlimited, the same types of books and magazines and other materials that they might be able to obtain at their libraries. And they've justified this with several doctrines in copyright law that Steve very meticulously reviews in his issue paper. The first is an invocation of what's known as the first sale doctrine, and its extension to the internet known as the digital first sale doctrine. So Steve, why don't you first kick off our discussion today by explaining a little bit of what is the first sale doctrine, how it has been argued to be extended to the digital context on the internet, how it's been received in the last 20 years as an argument, and whether this justifies what the Internet Archive has done.
Great, thanks, Adam. Thank you, Harold. Thank you, Adam. And thanks to the Hudson Institute for publishing my paper and for organizing this event today. I appreciate it. I think it's an important issue that really does need some focus. And even before I want to get into the digital first sale doctrine and the underlying first sale doctrine, I want to put it all in an even broader perspective for just a moment. Copyright has always been a reaction and interaction with evolution in technology and marketplace practices. That's true going all the way back to the printing press and the Statute of Anne in Britain, and through various different technologies, both in terms of new forms of expression like recorded sound and motion pictures, photography, and also copying and distribution technologies. The photocopier was a huge copyright issue in the 1950s. And so here we have yet another in this long sequence of the story of copyright. And the question is, how do we best address it? And in order to answer that question, I start with the wisdom of the founders of the United States Republic and the crafters of the Constitution, who wrote into the Constitution itself in Article 1, Section 8, Clause 8, the wisdom that giving creators exclusive property rights in their works is a market-based approach to promoting and incentivizing the creation and distribution of creative works, and that the public benefits from that. And I think as these broad principles of copyright are applied to specific situations that have come and go over time, that's really the beginning framework for any analysis. So with that in mind, the first sale doctrine is actually something that most Americans have probably taken for granted all their lives. It allows people to borrow books from libraries. It allows used bookstores to exist. It says simply, it started about 110 years ago, a little over, and the idea was when the copyright owner sells a particular copy of their work, a book, for example, and that is in fact the context in which it was first recognized, that the distribution right that's provided in copyright law, back then known as the right to vend, is exhausted after that first sale with respect to that particular copy. And the logic was the copyright owner has been compensated, and the court that originally founded this doctrine also tied it to restraints on tangible property, on the transfer of tangible property. And that was pretty well accepted. In fact, the Congress revised the Copyright Act generally in 1909, a year after the court decision Bobbs-Merrill that founded the first sale doctrine. And it explicitly included the first sale doctrine in the Copyright Act. And in 1976, when Congress again revised the Copyright Act, it included the first sale doctrine, although it changed the wording in an important way. It no longer actually depends on whether there's been a first sale. It says now simply that where a book was, or any, I should say, any work has been made lawfully under this title, meaning the copyright law of the United States, that the distribution right no longer applies with regard to that particular title. Okay, fine. So that works really well if you have your book, have your vinyl record, your DVD or CD that you bought and you own, and you no longer want it. Maybe you have a friend who wants it, and so you can loan it to them, you can give it to them, you could sell it to them, and the copyright owner has nothing to say about that as long as it was lawfully made. Now along comes digital technology, and people are, back in the day, downloading songs to their iPods. Now, of course, more likely to their smartphones. Can they give that song away? Well, that kind of changes the game, and in a number of different ways. If you just give away your CD, your book, you don't have it anymore. If you email a copy or use a peer-to-peer service to transmit a copy of a copyrighted work, you still have it, and now they have it too. So you've made a new copy, and copyright law has something to say about that. But it's more than just the legal technicalities of the copyright law. There's some practical issues here too, because in order to find someone who wants a copy of what you have, back in the day, you had to, maybe no one in your circle of friends actually wanted to read the book that you read or listen to the music that you listen to. And so you may not find anyone who wants it. Or if you do, maybe your friend's cousin, across the country wants it. Well, you've got to put it in the mail or somehow deliver it to them. There's time and expense involved in that. And of course, a used copy is used. You could have dog-eared, coffee-stained pages in a book, or a scratch on an old record or a CD or DVD, etc. Again, all of that changed with digital technology and combined with the distribution environment of the internet. Now, you put it on eBay or similar auction site, and virtually instantly, someone out there is likely to like it, no matter how eclectic your tastes happen to be. And the transmission, of course, is instantaneous. It's essentially cost-free, and the copy is delivered in perfect format. It's 100% equal in quality to the original. And so what we used to think of as a secondary market for used items all of a sudden becomes a primary market. It's the same as the primary market. Mm-hmm. It feels like to some people, or at least they try and make the case that, well, it's just the same idea. And so about 20 years ago, people started coming up to policymakers saying, well, we should update the first sale doctrine, and we're going to call that the digital first sale doctrine, so that I should be able to, what they called, forward and delete. So yes, it's true that they would acknowledge when I have a copy and I transmit it, I still have my copy, but what if I promise to delete it? Or what if we even have technology that will disable my access? Doesn't that essentially make the same, get to the same result as the first sale doctrine has for a long time? And the Copyright Office was asked to do a study on exactly this issue, among other things. It issued that study in 2001, and I had the privilege of working on that, and in fact, I was the primary author of this section of that report, known as the DMCA Section 104 report. I'm afraid we weren't so good at giving our reports fancy, exciting titles, but it was accurate because it was commissioned by Section 104 of the Digital Millennium Copyright Act, DMCA. Anyhow, as we looked at the issues, we really determined there were three concerns that made the so-called digital first sale doctrine not equivalent to the first sale doctrine. One I've already mentioned is that the first sale doctrine is a limitation on the distribution right, and the digital first sale doctrine would have to become a limitation on both the distribution right and the reproduction right. And there was no precedent for that. Two, as a practical matter, as I've also outlined, the effect on the market is completely different. And this goes back to first principles. When Congress adopted the first sale doctrine back in 1909 and again in modified form in the 1976 Act, it understood that there were practical limitations on the use of copies of works, the distribution of those copies, that would limit the effect and the harm to the market for the copyright owner. Now, it's not to say that transactional friction is a good thing, but the point is the exception was adopted precisely because it was of sufficiently limited harm to the copyright owner that it would not undercut the basic principle of copyright law, which is to promote the progress of science and knowledge through the provision of exclusive rights to copyright owners. And if exceptions become too broad in their effect or in their language, then you're really undercutting that purpose. And the Copyright Office back in 2001 recognized, this is a primary market, it's not a secondary market. And it's going to be too much damage to the copyright owner to justify that sort of change. And the third part was the notion that technology could solve this for us, that, oh, don't worry, no one will keep a copy because the technology will prevent it. We weren't convinced back in 2001 that that technology even existed, and recognizing that technology progresses, even if it came about, it could be defeated, as we've seen many times. And so the office recommended against adopting the digital first sale doctrine. The Patent and Trademark Office, in partnership with the National Telecommunications Association, agency, recently, or more recently, revisited this issue, and they issued a report in 2016, and they said, you know what? What the Copyright Office said 15 years ago is still true today. It would be a substitute for the primary market, and it would be too much harm to the copyright owner. And so despite 20 years of advocacy from folks who would like to see this become the law of the land, neither the Copyright Office nor the Patent and Trademark Office nor NTIA nor Congress, because of course they've gone directly to Congress, have accepted this as good copyright policy. Nonetheless, what the Internet Archive, and I'll just call them IA for short because it's a little more efficient, what IA is arguing is, well, we may not have been able to amend the first sale doctrine in the statute, but fair use can be anything. And so we're going to argue that the first sale doctrine, the digital first sale doctrine, is permissible under fair use. And that's really the thrust of my article because, excuse me, that's really the thrust of my article because taking a 20-year history of failed advocacy that has failed precisely because of the harm it would create to copyright owners and the damage it would do to the incentives that are at the heart of copyright law does not go away simply because you want to talk about it in a different section of the Copyright Act. And in fact, of the 4 fair use factors that must be considered, the 4th, and many consider the most important, is the harm to the potential market and value for the copyrighted work. And that is the point at which the proposal and the argument made by IA and its supporters really falls flattest. The 4 factors include the nature of the copyrighted work, the nature of the use, excuse me, the nature of the work, whether it's creative or not creative, the amount and substantiality of the portion used, and like I said, harm to the market. And in my article, I'm willing to concede that IA's use is nonprofit. Now, there are some who actually would argue otherwise, but I'm going to give them the benefit of the doubt there. I wanted to take as generous and a fair approach as I could in this,
right,
to give them every chance. And so, okay, fine. They're not charging anything. It's a not-for-profit entity, and they even make claim to some educational purpose. Although it's important to remember that when IA created this so-called National Emergency Library, it's really just a name because it's the same works that they've always had, the works that they make available for download and distribution are not limited to those that have pedagogical value. It's everything. So there is some educational use to it, but there's also use that is not necessarily educational. Nonetheless, in the article, I gave them credit and I said, okay, first factor goes in favor of the IA, but the other 3 factors don't. The second factor, we're talking about creative works, things at the heart of what copyright is about. Books first and foremost, but they also have recorded music and audiovisual works and all sorts of things. These are the heart of what copyright is. The third factor, the amount and substantiality of the portion used, again, this is not a difficult analysis. They're allowing people to download the entirety of the work. So it's everything. That factor clearly goes against the IA. The fourth factor is where they work the hardest to try and make their case that they're not harming the market. And they talk a lot about, there's this memo on controlled digital lending. And just a moment, let me talk about the terminology that's used. The IA calls itself a library. They talk about lending, but it's an internet site. It's a platform that allows downloads. And the rest of the language really is more geared towards engendering sympathy with the public than accurately describing what they do. I understand that IA opened some sort of physical office in California where people can actually go in and get a book like a real library, but everyone understands they are first, second, third, fourth, and fifth an internet website that offers downloads. The rest is really just for show. So they're trying to argue that the safeguards that they put in place limit the harm to the market. And I went through in the article the 6 safeguards that they suggest, and none of them really do the trick. They say that they're limiting the amount of time that people can have access to the works. That used to be true. The way that they would work is you could get a download and it would be active for 2 weeks, and then you would no longer have access. If you wanted to get it for longer, you couldn't just renew it. You had to get back in line, so to speak. And what that meant was, for every copy that they had made, they would only allow one user. But that's the limitation they've removed now since March 24th of 2020. So now there's an unlimited number of users per copy that they've made. And so there really is no 2-week limitation. You just renew it immediately if you choose to. And that numerical limitation is something else that this CDL memo cited as an important safeguard, but it's something that they're not doing. Further, they talked about technology that was limiting the further reproduction and distribution. So, for example, if I download a copy from IA, I can't then send that to you. There's technology that prevents that. Even assuming that technology can't be defeated, and I don't know how easy that might be, that it's a good thing, and it addresses further downstream harm that I might do, or any user of IA might do, but it doesn't address the harm that IA did by allowing me to obtain the download without paying for it. And so it doesn't really address IA's point. Mm-hmm. And they said, oh, well, IA only uses lawful copies, and they adhere to licensing terms. And this one's kind of funny, because IA really is doing a sleight of hand here. They talk about how, well, we only use lawfully owned copies of books. But what they do with those lawfully owned copies of books is they make new copies of them and put them on their servers. So there's a whole important question even before this fair use analysis. Are the copies that exist on IA's servers lawfully made? And it appears there are 3 ways IA gets its copies. One, people donate hard copy books to them, or they purchase hard copy books, and then they scan those. And then the third option is there are libraries that let IA come in and just scan everything in the library, a la the Google Books situation. Mm-hmm. Now, listeners might be saying, wait a minute, Google Books was permitted to go forward. The Second Circuit ruled in favor of Google Books, and that's true. But Google Books is much more limited than what IA does, precisely because the Google Book scanning is only intermediate scanning. You cannot go on to Google and get a complete copy of that book. They proposed that in the settlement that was rejected by the court and opposed by the US government. But in fact, all you can do is search, and Google made highlighted this quite prominently in their arguments to the court. All you get is a snippet, a line or two from the book as a result of your search. Not so with IA. You get the whole work. And so the Google Books litigation is no useful precedent here for the copying that IA is doing. They're not doing intermediate copying. They're doing copying for the purpose of providing the entire work. Nor do they appear to have legal authority even to be making copies of the books where they own the physical copy of the book, because again, that's a new copy. The copyright law is named for the reproduction right, the right to make copies. And here IA is just saying, well, no, we can do that, no problem. And they're almost glossing over that entire question in much of the argumentation that they put forward. But it shouldn't be ignored. It's an important underlying question, because if those copies aren't lawfully made, and there's good reason to think they're not, One, IA may be an infringer right there and then. And two, they're making all this argument about the so-called digital first sale doctrine. But if the copies that are on their servers are not lawfully made, they don't even qualify for the current statutory first sale doctrine because they're not lawfully made under this title. So they've really got several layers of problem to what they're doing. Maybe I should pause there and see if there's anything else you wanted to delve into in particular.
Well, I had definitely some additional questions, but Harold, do you have anything you'd like to ask of Steve?
I have a lot of questions as well. I was going to ask him about, so if COVID-19 happened when Rockster or Napster or Area or YouTube courts were deciding them, would they decide them differently? Is this fair use has come up many times before, and the courts have sort of shot these theories down. Why is IA different?
So great question. Thank you, Harold. IA really is putting all its eggs into the basket of it's coronavirus, everything's shut down, and fair use lets us do anything we want during a national emergency. And that's simply wrong. It's the copyright law doesn't get suspended because there's a national emergency. In fact, historically, I went back and looked, see what have we done as a nation in prior times of crisis. So, for example, at the very foundation, the very beginning of our democracy, under the Constitution, President Washington used the very first State of the Union address to scold Congress. You haven't passed a copyright law yet. Get on that. And they did a month later. This is a point. It's important to remember. The country had just come out of the failed Articles of Confederation. We had all sorts of debt from the Revolution. The future of the Republic was uncertain. And yet President Washington took time to talk about copyright. Similarly, literally weeks before the first shots were fired at Fort Sumter, Congress enacted an amendment that affected the copyright and patent laws, providing for appeal of those cases up to the Supreme Court itself. So the nation was getting ready to tear itself apart, and yet Congress was focused on strengthening intellectual property rights. And perhaps most directly relevant to the situation now, during the height of the Great Depression, with 25% of the American workforce out of work, not only for a few months, but in some cases for years, Congress came very close to providing for a wholesale change in US copyright law that would have given broad protection to foreign works and removed many of the formalities that were practical barriers to protection for many people for many years. That passed the Senate and was the subject of 27 days of hearings. Can you even imagine 27 days of hearings on a copyright issue? In the modern context, it's almost unimaginable. But they did it, again, in the middle of the Great Depression. They were talking about broadening copyright protection and protecting foreign authors. So there's actually a lot of precedent for using national crises to advance intellectual property, copyright in specific, but I think patent as well, because Congress has understood for a long, long time that intellectual property promotes economic growth. It helps the public. IA and its supporters fundamentally disagree with that notion, and they're entitled to their opinion, but that's not the vision the founders put into the Constitution. Harold, your question is important for another reason as well, because the IA has tried to say, look, what we're doing has very little harm. There was an exchange of letters. Senator Tillis of North Carolina, who's chair of the Senate Intellectual Property Subcommittee, sent a letter to Brewster Kahle, the founder and head of the IA. asking some pretty tough questions about what they're doing right now. And Brewster wrote back and said, look, there's not many people using it. They're only using it for a short time. It's not that big a deal. But that's not the way fair use works. It doesn't say, oh, well, this particular instance, it doesn't seem too bad, so we'll let it go. No, as even the CDL memo acknowledges, the test is, if everybody did this, how would that harm the market? What would be the effect on the market for the copyrighted work or potential market? And if everybody did this, well, yeah, those file sharing sites might well have a claim to legitimacy when we have multiple circuits and Supreme Court precedent holding very clearly that those are infringing. And we even have a Second Circuit decision specifically on the exact question that IA puts before us. Is a digital first sale doctrine fair use? And in a case involving a company called Redigi, which purported to create a marketplace for used music online, Judge Laval, who is the unparalleled champion of fair use in modern times, held it was clearly not fair use, that it was very severe harm to the market, and rejected all the arguments that IA is making. Now they turn around and they say, well, don't worry about Redigi because that was a commercial service and we're non-commercial. But actually, that cuts the other way when it comes to the harm to the market. I acknowledge, I give them the benefit of the doubt that as a non-commercial entity, that they would prevail on the first factor. But the fourth factor, the harm to the market, well, where's there going to be more harm to the market? Where you're charging people something like Redigi did, or where you just give it away entirely for free like IA does? So if anything, I think it's pretty elemental that IA's harm to the market's even worse than Redigi.
Now, fantastic of how the historical context for the ongoing protection of intellectual property, even during times of national crises, wars, and depressions. But are there also other legal solutions to that are available to people who wish to use copyrighted works during times of crises, or is ultimately a fair use type argument the only thing that's available to an organization that is stuck given various shutdown orders and quarantines and other types of restrictions that are imposed upon people that prevent them from interacting in person, such as educators, for instance, who can no longer educate their students in person anymore, such as myself and Harold and yourself, right? We all have experienced this, our online teaching. Are there other solutions available to people?
Thank you for that question, Adam. That's a great question. And of course, the answer is yes. And in fact, it just so happens that I had an opportunity to play a particularly relevant role in helping to craft the terms of what's known as the TEACH Act, Technology, Education, and Copyright Harmonization Act. That was enacted by Congress in 2002 as the result of a Copyright Office study, which then became, after some congressional hearings, a private sector negotiation over the exact qualifications and terms. I had the opportunity to mediate those negotiations, and we produced a consensus approach that Congress enacted. And the idea was to create an exception in the Copyright Act, and it's codified at Section 110(2) for those who might be interested in looking it up. The idea was to allow educators to replicate the classroom environment in an online digital setting, exactly what educators across the United States are trying to do right now. And it allows, by its terms, the copying and public performance of certain copyrighted works in limited portions so that it's allowing educational activity to occur, but not to such a degree that it's going to unduly harm the market for the copyright owner. And There are some requirements to put technology in place and have policies in place to promote copyright, to prevent further downstream uses, the sort of thing the CDL says are appropriate. At the beginning, back in 2002, 2003, a lot of institutions felt like some of the technological requirements to prevent further copying, that sort of thing, were a bit burdensome because that technology wasn't as well developed back then, and fair enough. But times have changed quite a bit. We're all, virtually all of us, are on an almost daily basis on these video conferencing platforms that by their nature limit who can be on. You've got passwords, you restrict people by invitation. I know from teaching at GW, when I want to post works to my students, I limit it. It's necessarily limited to my class, which is one of the conditions of the Teach Act, and I can also limit the date range through which it's available. So, particularly for many of the large, sophisticated institutions, this really is a very useful tool. And again, the authors of the CDL memo wrote a blog that essentially acknowledged that. I'll fairly acknowledge that for smaller institutions, less sophisticated institutions, there might still be some burdens. But what's really interesting to me, and a little bit troubling, is that so many of these large institutions have flocked to the IAE's defense for this essentially unregulated, unlimited use of other people's copyrighted works, when the Teach Act is there all along. Now, the Teach Act's not a panacea. It's not going to solve every problem. Publishers have also stepped in. I've actually been doing some work just this past week with my local school system, advising them and trying to help them get copyright clearances for what they want to do. And we found that many of the publishers are providing very broad blanket permissions. So between the Teach Act and what publishers are voluntarily doing, there are a number of tools in the toolbox. And if your goal was exclusively to promote pedagogical uses, you would think people would use every tool in the toolbox. So why are we only hearing about IA and this broad, unregulated, make everything available? So why are we hearing only from IA about this broad, unregulated, make everything available to everyone, no limits? It raises some questions about whether there's a policy goal here as well. And I think that's pretty clearly why some people on the copyright owner side have gotten quite upset about what IA is doing. Because when you take all this history and analysis, 20 years of study, review, analysis by expert agencies, Congress, courts, all of whom have come to the same conclusion that this is not good policy. This is not what the law says, and it shouldn't be what the law says. Why would you go ahead and do that anyway? We still live in rule of law even during a crisis, and maybe rule of law is even more important during a crisis than any other time. If the only reason you think you can get away with it is because judges wouldn't want to appear to be a bad guy, quote unquote, and shut it down in the middle of the crisis, that's not rule of law. And it's a good illustration of why making major changes to longstanding copyright law and policy in the midst of a major crisis isn't a thoughtful or careful way of proceeding.
Well, it's interesting that you mentioned the Google Books project earlier, and the litigation and adjudication of the claims to fair use in that case. That's not the only fair use argument that we've heard from Google of late. There is a very prominent case that was actually delayed at the U.S. Supreme Court in Google v. Oracle, involving whether Google can use Google could viably copy over 11,000 lines of code in what's known as Java. And Google has asserted, similar to in Google Books, a fair use argument that justifies this. Do you see implications between or connections between the fair use claims and arguments by IA and what's happening in this other case that can maybe give us some insights into how the court or ultimately copyright law experts such as yourself may be resolving this issue as well?
So another great question. Thank you, Adam. It really gives you an insight, I think, into the world that some people would have us live in when you take all of these issues together and not just as one-off. If it's okay for essentially any website that doesn't charge money to copy other people's works and make them available for download, as Harold's question earlier illustrated, and as IA is doing, and it's okay for commercial competitors to copy each other's copyrighted code and use it in direct competition with the copyright owner, as Google did in the Google versus Oracle litigation. And it's okay, as Google would have had us believe, for them to scan tens of millions of books verbatim and then be able to sell copies of those books, as they would have been able to do had the settlement that they put forth to the court been approved. Well, gosh, it's pretty clear that there are people out there who just don't want there to be any effective copyright. And put all those together, and the world is essentially an all-you-can-eat buffet of other people's copyrighted works. And I mean, again, go back to first principles. James Madison chaired the subcommittee that wrote the Copyright and Patent Clause, and he defended it in the Federalist Papers by saying that the need was nearly self-evident, and that the application of private rights was fully in concert with the public good. He understood fundamentally that the incentive of a market-based system of private rights being used to prevent free riders from interfering with creators and inventors, in the case of patents, from being able to monetize and distribute their creative and inventive works was fundamental to the development of our economy and our society, both culturally and as a knowledge-based economy. These sorts of arguments that would falsely pit copyright against the public interest are not only counterproductive in the here and now, they are fundamentally at odds with the constitutional vision for intellectual property. And full disclosure, I filed an amicus brief before the Supreme Court in Google versus Oracle, and I made exactly that point.
And I highly recommend any viewers of this to Google that amicus brief to read it. It is indeed an excellent brief. Harold, any further questions?
I think we're probably coming up at a good closing point here. We really want to thank you, Stephen, for joining us today at Hudson to teach us about copyright law and COVID-19 and better understanding just how important copyright law is and why it should be protected. So on behalf of Adam and myself, thank you again so much for joining us today, and we look forward to hosting you at Hudson again in the near future.
Thank you very much. It's been my pleasure.
Thank you.